Hello, everyone. This is good evening from India. I'm Ashish Agarwal. I lead the public policy work at nasscom. nasscom is the leading voice for tech industry in India with over 3,000 members and a lot of you joining us across the world. It's good morning and good afternoon. As you're aware, India has recently enacted the Digital Personal Data Protection Act, or as we love to call it, DPDPA. And you will see a lot of acronyms if you discuss data protection privacy in India. And now we are expecting the draft rules to be enacted, to be released very soon for discussion, probably sometime this month. So now, as part of our knowledge series on the way forward, I am delighted to welcome all of you to two panel discussions today, where we'll be discussing important questions on how to think about consent as a basis for processing personal data. Each panel will be 1 hour of duration, and we'll have a 10-minute break in between. We are doing this webinar in partnerships with the Future of Privacy Forum. As you know, FPF is a not-for-profit doing some leading work on privacy and data protection across the world. We're delighted to partner with them. I'll be moderating the first panel today with Bianca Marcu. Bianca is the policy manager for global privacy at the Future of Privacy Forum. In both these panel discussions today, we'll be focusing on the key considerations on making consent under the DPDPA meaningful. So in fact, in panel one, we'll be focusing on designing notices and requests for meaningful consent. I now welcome our experts for the first panel. We have with us Paul Breitbarth. Paul is the DPO at Catawiki, a Dutch online marketplace, a visiting professor at Maastricht University, and a member of the Jersey Data Protection Authority. Now, he has worked in the public and private sector in multiple privacy roles, including the Dutch Data Protection Authority. He was also an active member of the subgroup in the Article 29 Working Group, the predecessor of the European Data Protection Board. So it'll be great to listen to your thoughts on when you kind of think about it in the Indian context. So welcome, Paul. And then we have Unjin Han. She is a consultant at Roos, a law firm, law and consulting firm, focusing on the emerging markets. So again, very relevant from an India perspective. She's a lawyer, and then her breadth of practice is across various segments of the industry, the IT, telecommunication, and then, of course, beyond just data privacy, she also looks at cyber security. And then she has also looked at some of these verticals like fintech, e-commerce, and she also has an expertise in commercial transactions. And then we have Swati Sinha. Swati is the APEC, Japan, and China Privacy Officer for and Senior Counsel at Cisco, where she specializes in data privacy, GDPR implementation, privacy risk, and governance. So again, Cisco is a member company, and we have been engaging with them a lot, but we love to get a view from the lens, Swati, that you are looking at, and then put the Indian requirements in that context. And we also have a panelist who is not yet here, but we are expecting him to join soon, Eduardo Ustaran. He's partner at Hogan Lovells. Again, a very important voice when we think about a privacy conversation. So hopefully he can join in soon. And just to get this discussion going, my colleague Priyanshi will just give us a very quick refresher on the questions that we are covering on notice and consent. So Priyanshi, will you walk us through that, please?
Sure. Thank you so much for that, Ashish. I will just, like Ashish mentioned, I'll quickly discuss the fundamental aspects that are outlined in the framework of the Digital Data Protection Act on notice and consent. The first key thing to keep in mind is that the Act has separate sections for notice and requests for consent. It lays down so coming to notice in Section 5, subsection 1, the Act states that for every fresh request for consent, there should be a notice that is accompanying or preceding it. And then it lays down a close list of what the notice should contain, which is the note regarding the personal data that is being processed, the purpose for which it is being processed, how the data principal, which is the data subject under our law, should exercise the right to withdrawal and grievance redressal, and how the data principal can make a complaint to the Data Protection Board. And then in delegated legislation, that is through rules, the government can set out the manner in which the notice shall inform the data principal. And now coming to requests for consent, specifically under Section 6. Section 6 is the general provision that deals with consent in the Act. It requires that every request for consent should be in a clear and plain language, and that it should provide the details of the DPO or other point of contact. It is DPO and other point of contact because under our Act, only significant data fiduciaries have to appoint DPOs. And data fiduciaries are the data control equivalent in our law. A key point here again is to note that the Act requires that the data principal shall have the option to access notice and consent requests in English and other 22 languages that mentioned in the Indian Constitution. I will also quickly mention the standards of valid consent that are mentioned under Section 6(1) of the Act. It says that the consent that is given should be free, specific, informed, unambiguous, unconditional with a clear affirmative action, and that the consent shall signify an agreement to processing personal data for the specific purpose. And that the consent given should be limited to the personal data that is necessary for the specified purpose. Now here it is also important to look at the illustration that the Act provides to describe this well. The example here is that Y is a telemedicine app, and Y is requesting for consent for one to ask for personal data for telemedicine services and also ask for access to the phone book of a data principal. Now, the Act clarifies that because access to phone book is not necessary to provide telemedicine services, the consent will only be limited, the consent that is provided should only be limited to the personal data that is sought for telemedicine services specifically. And then the Act under Section 6 itself clarifies that in case there's a proceeding that happens, that the onus is on the data fiduciary to prove that the consent that was taken was in accordance with the Act itself. The Act then also separately deals with notice requirement for processing that is based on consent that is collected prior to the Act. It says that if a fiduciary has collected consent prior to the Act, it is required to inform the data principal. Also note it says inform the data principal. It does not use the language of request for consent here. It says it will inform the principal about as soon as practicable and through a notice. And then the contents of the notice, again, here is a close list like it was in the previous section about the personal data that is being processed, the purpose of processing, etc. Now, here the data, important thing to note again is that the fiduciary can continue processing data based on the consent that was collected prior to the Act until and unless the data principal has withdrawn her consent. Now, the standard for consent withdrawal again is under Section 6, where it says that the standard for that the data fiduciary is supposed to follow for consent withdrawal is that the consent that is the withdrawal of consent should be as easy and it should be comparable with the ease with which it was given. And the effect of withdrawal on the data fiduciary is that they have to cease processing the data and cause the data processors also to cease processing the data unless it is required under any other law. That is it. This is broadly what the Act says on notice and consent. And thank you, Ashish, over to you.
All right. Thanks, Priyansha, for that refresher. All right. So, Bianca, now may I request you to start off this discussion? And I notice, Eduardo, you are right on time. We just kind of are going to get started. So we did introduce you a bit, but I'll do a little bit more. So you are a partner at Hogan Lovells London, a prominent global law firm, where you are leading the privacy and cybersecurity practice. And of course, your multi-decade experience will be very relevant as we walk through some of this and really looking forward to your interventions as well. So Bianca, over to you.
Thank you very much, Ashish. Hi, everyone. And thank you, Priyanshi, for the presentation introducing India's Digital Personal Data Protection Act, the DPDPA. I'm very happy to be with you today on behalf of Future of Privacy Forum and of course, to be joined by such a wonderful and expert panel. So let us get straight into it. As we've seen in Priyanshi's presentation, data fiduciaries are required to ensure that consent is free, specific, informed, unconditional, and unambiguous, and with a clear affirmative action. So that's quite a few requirements here. And With this in mind, Paul, perhaps I can pose the first question to you so that we can start to unpack these consent requirements. What does it mean exactly for consent to be free, specific, informed, unconditional, and unambiguous?
Thank you, Bianca, and thank you all for the invitation to be here today. What that means is that it is a very complex world, because it is not an easy thing to meet all of those requirements straight away. If we look, for example, at offering users a valid and a real choice, that is already something that you need to think about. Is what you are asking the individual, is that really something that they would be able to agree to, or do you basically force them to say yes to share their personal data because there is no other way the service could be used? Actually, this week we've started a debate in the European Union on a new consent model that Meta is introducing for Facebook and Instagram, whether that is a free choice for users, asking to be agreeable to be shown advertising or to pay 10 to 13 euros a month in order not to be shown advertising. Is that a free choice? And without going into the whole detail of that debate, that's not for today, but it is something that data fiduciaries should think about. And then also users should be informed, so they need to understand what it is that they are saying yes to. Also there, data processing in a lot of upcoming economies, for a lot of people, will be something that they have not thought about before. In India, of course, we know that data protection is a fundamental right, as also confirmed by your highest courts. But even then, that message may not have reached every single individual on the Indian subcontinent. So also they're explaining why this is important, not just explaining this is how personal data is processed, but also why do we need to tell you, and why does that matter, and what could the consequences be? I think also that is fairly important. Maybe leave it there as an introduction, because I'm sure that the others have additional things to bring to the table.
Thank you, Paul, for this introduction. I think we're already starting to get a little bit of a clearer idea of these complex requirements, as you said. And just to go a little further, Yoonjung, I wonder if I can turn to you and ask, for example, what comprises really a clear affirmative action in practice, and how does this compare to, for example, the consent requirements that you've seen, for example, with the Personal Data Protection Decree in Vietnam? What are a little bit the practices across the region there?
Right. Yes, thank you, Bianca. So yes, as you may be aware, so in Vietnam recently issued the Personal Data Protection Decree in just April of this year, and that went into effect on the 1st of July. So it's very fresh here. And so prior to that, all the regulations had been kind of spread across different legislations, but now we're seeing a consolidated piece of legislation, which is the PDP decree. And so now under the PDP decree, consent is defined as an act that must be informed, meaning that organizations and individuals, they need to ensure that data subjects are fully made known about the type of personal data that is being processed, the processing purpose, the processing parties, and the data subject's rights and obligations. And then consent has to be voluntarily given, freely given, and it needs to be clearly and specifically expressed in an affirmative action. Also, the PDP decree says that silence and non-response shall not be regarded as consent. And so here in Vietnam, what we're seeing is we're seeing the GDPR influences, and so we are seeing a lot of the business operations taking using the GDPR as a reference point, and utilizing existing forms and existing practices and applying that here in Vietnam.
Thank you, Injung. It's really interesting that we're starting to compare the requirements across the different countries and indeed across the different regions, because all of the data protection laws are having a huge influence on each other. So having kind of understood a little bit the stipulations for valid consent, of course, the next step that an organization might have in mind is, how do I, as a data fiduciary, start to design notices and requests for consent? So Swati, I would turn to you for this question. In India's Data Protection Act, how can data fiduciaries begin to design such notices and also to really demonstrate the validity of the consent that they have obtained?
Sure. Thank you so much, Priyanka. And it's an absolute pleasure to be part of this panel. So in answering your question, I would take the liberty of also taking some examples of how consent and notice models have been interpreted in other jurisdictions. Now, when we talk about consent requirement as it relates to notice and choice, they are unfortunately quite fragmented and have not really been adopted with the level of uniformity and coherence that was really needed. Having said that, consent, what we see is that consent is still being relied upon as the most common criteria or the default legal basis for processing of personal data. There could be like several contributing factors to this, especially in the APAC region, where consent may customarily be associated with the notion of an individual's expression of autonomy or control, or because different countries have had their own experiences with personal information exploitation. They're very culturally different, and more so they are comfortable with relying on something as known as consent versus other legal basis. But however, the over-reliance on consent has resulted in tick the box or I agree approach, resulting in issues such as uninformed consent, consent fatigue, unnecessary compliance due to contradictory requirements. And this was one of the reasons why some of the countries in this part of the world, such as South Korea, Philippines, Singapore, really made changes in their laws by recognizing and pushing for companies to adopt alternative legal basis for processing. But now that we're talking about India and our notices should be designed, we need to understand that we have given with really limited options in terms of legal basis. And the regulatory or the government stance is very clear in terms of focusing on consent. So at this juncture of the Act's adoption process, the policy making and corporate interest should really be focused on rendering consent to become more meaningful, and probably taking this as an opportunity to learn from other jurisdictions where they've operationalized or assessed notice and consent requirements. And talking about other jurisdictions, I would like to highlight an example of something that we've seen under the GDPR. Just to make it clear that consent is not the most popular basis for processing personal information under the GDPR. But a relevant reference example that we can probably take is how notice and consent is presented with cookie consents. Now, India also has a very specific requirement in terms of how consent should be unambiguous, unconditional, specific, informed, voluntarily, and so on. So I think in this specific context, referring to cookie consent notices for how cookie consent notices are presented for different categories of cookies is quite relevant, because from the time that GDPR was enforced, organizations were really compelled to present and obtain consent for different categories of mostly unnecessary cookies that process personal data for different purposes. And if you see that in these cookie consent notices, it is quite intuitive. There are different categories presented with the toggle off or on button, depending on whether you want to activate certain cookies or not. Information is relevant. So there can be an argument that the notice provided would be good enough for individuals to understand and to make an informed decision. However, when we are relying on something as something like a cookie consent model, what we need to understand and stray away from is some of the challenges that we faced in this adoption in other jurisdictions, like how different consent will be captured, or making sure that different purposes are not bundled together, drifting away from dark patterns, pre-ticked boxes, and so on. Also, I think when we are talking about notice and consent solutions, we can talk about South Korea and China, where the notice requirements are extremely granular, and there is a very specific requirement of obtaining separate consent. Now, the way companies have operationalized the processing or obtaining processing of personal information by virtue of relying on consent is by presenting different tick boxes. Now, each tick box is comes with, or redirects you to a link, or would probably open a layered notice or a pop-up window, which would provide relevant information to the individual as they are providing or selecting the relevant tick box. So these are some of the models that we can probably look into as we are thinking about different notice and consent models.
Thank you so much, Swati, for those insights also across the APAC region and really comparing the practices happening in the different countries. And it's interesting that you're starting to mention some of the challenges, and I'd like to turn over to really go into what organizations might face in this sense. So, Eduardo, I'd really like to turn to you, and I wonder if you can share with us what some of the challenges are that you're seeing in practice, both in obtaining valid consent and really in demonstrating compliance with these requirements. What are some of the practical use cases that you've come across, and how are organizations effectively addressing these challenges?
Thank you. It's a very important question to address, particularly given what we are hearing about the way in which consent is becoming such a essential element of compliance from a data protection perspective in so many jurisdictions. And in Europe, we've seen that evolution from the days of the European Data Protection Directive to the GDPR and the way it is interpreted by the courts. And I think what all these jurisdictions have in common, including Europe, is that there is a sense that the validity of consent is of such high standards that organizations need to really try hard to obtain consent. So I think it is in that context that I think there are two main challenges that I see in practice. One is the bit about the indication of wishes. So how someone, or if you are implementing a consent mechanism, how can you ensure that in an easy way, someone specifically says, yes, I don't mind, or yes, I want this to happen? Because what we saw in Europe, for example, in relation to cookie consent, that for years, this was more of a sort of, okay, well, if you use this website, we assume you consent. And it was almost like an assumption. That, of course, the court said that's not valid consent. That's not an indication of wishes, that no one is expressly saying this. And I think that's an evolution that we are seeing, to the point that in some jurisdictions, not only someone is required to click a button saying accept, they need to tick a box. And I think that is a complexity in the online world where everything happens so seamlessly that we are seeing. So that's one element. And then the second element, which is perhaps the most difficult from the point of view of the concept of consent, is how you ensure that that consent is freely given. And that's not something about a mechanism on a screen that someone needs to press a button or anything like that. It's more about the circumstances of the situation that are such that when someone presses the button or ticks the box or clicks yes on the screen, that is not an assumption that everybody will do that, because otherwise they're not going to have access to the service they want to. And that is probably the most challenging aspect in Europe, and I predict it's going to be the most challenging aspect in India and in all other jurisdictions where consent is required. To what extent people can demonstrate, or if you have someone consent, that is truly freely given, that is not a condition of a service. You can only get this if you give us your consent, and it's take it or leave it. And I think that is what is going to really test the validity of consent going forward. And I think that's probably the biggest challenge I see in practice.
Thank you, Eduardo. Before I hand over to Ashish, I'd like to also ask Paul, in terms of your practical experience, what are some of the aspects that organizations should keep in mind here from your experience to address these challenges, really in a practical way, keeping records of consent, for example?
Well, I think a few things. First of all, do check if consent is the legal basis you operate under, because also in the DPDPD, there are other legal grounds to process personal data. For example, if the state is involved or in the employment context, you see that consent is not always required. So do check that before you set up a whole consent framework. I think that's recommendation one. Two, indeed, you need to document the consent that you've been given. We mainly use consent for two reasons in my own company, which is on the one hand for direct marketing purposes, certain newsletters, and on the other hand for cookies. And we use tooling to make sure that is properly documented. So for cookies, we have a cookie banner both on our website and on the mobile app that makes sure that there is a record of the user's choice, and that is also retained for subsequent visits for X amount of time. And for direct marketing, we have user settings in their account profiles. As Ashish mentioned, it's mainly an online marketplace, so there is a user account where you can indicate those preferences. So that makes it fairly easy for us. When it comes to the information, I've done a first updated iteration of our data protection notice last year, mainly aimed at making sure that everything was properly structured and formulated slightly easier than it was previously. It used to be a very legal document that, well, it's slightly easier now. I have still the desire to make it more understandable, because I don't believe it's yet at the level where everybody would be able to understand it. So there is work to be done. But let me also share what my dream would be for providing notice. And that is that we use much more visuals and video to actually provide that information. I think everybody who has ever been on a plane knows these airline safety videos, where in 1 or 2 minutes you get all of the safety information for your flight. And I think it would be great if companies would actually start using those to also tell users about providing, or to use them to provide notice, to tell them about their data processing operations, just in a slightly fun, accessible, visual way. This will happen with your personal data. And that also means that you would be able to provide subtitles in all of the different languages that can be used, or even voiceovers if that is easier. And you can make it suitable for a small screen, because also there we have to realize maybe in Europe and in North America, everybody is behind their laptop. But more and more people are only on their mobile devices, on small tablets, on phones, and the information that you provide needs to be also accessible and understandable and relevant on such a small screen, which with long legal text of 5,000 words, that's very annoying to read on a smartphone. So also there, let's take that into account when providing information to individuals.
Thank you, Paul. I think that's wonderful and really quite a creative idea. And how can we make a more understandable and more accessible the extent and the scope of data processing to a wide variety of individuals? So that's brilliant. Ashish, if I can hand over to you.
Thanks, Bianca. And so I have a few general questions. We have been talking to industry and as I mentioned in the very beginning, that there's a lot of industry for which it's the first time to kind of implement a full-fledged privacy law. And Paul, if I can just take a follow-up on what you just last said, and I think what you said is very important, because making that notice understandable and relatable to the user, and to Eduardo's point that it's also about the context in which the consent is being sought, that visual element is very important. So from an industry point of view, when you think about this, should they be worried that such a approach, will it meet the legal test of the notice, or is that something that should not be a huge worry, and that is something that once you start doing it, you'll realize that both from the regulator point of view and your own compliance point of view, that is something that can actually be an effective strategy? I mean, just a quick comment on that, and also if somebody else wants to comment after Paul. Yeah.
Well, I think you will always also have a written notice and not just have a video. But yes, I do believe that also a video is suitable to provide information in an accessible manner. I think that would also be allowed under the GDPR. I have to be honest, I did not check the DPDPA in that detail to see whether the notice always needs to be provided in writing. But I think, I mean, lawyers will be lawyers, so we always would also like to be put something in writing. I know that I would, and probably Eduardo as well, just so that it's there. But we should also think much more with the head of user friendliness and their videos or audio or cartoons or what have you to make it slightly more accessible and certainly a bit more fun. Would also help, and that also makes sure that the message lands a lot better with the user.
All right, great. So as my colleague Varun just clarified on chat, that we don't necessarily need a written notice under the DPDPA. So I think that's just one comment on that. Okay, so just to pull back from this, I think one of the things is that in our act, there is no formal mechanism for guidance to therefore, help industry walk through this journey, not only in consent, but in many other aspects of compliance. So given the fact that you have as industry, and this is a question for all of you, and please feel free to come in, are there examples in terms of best practices that we can as India look at to say that, okay, fine, this is a good starting point, because otherwise the option is only for somebody to get burnt at the redress board, and then for the rest of the people to figure out that that's not a good thing to do. So that's the high level context. And within that, one sub question is that is the standard of consent, in your experience, when the regulators are kind of looking at it, is it applied pretty much in a standard manner, irrespective of size and scale of the organization? Or do you find that when they are actually looking at the practices, they kind of have a differential view of how they look at somebody who's a large platform vis-a-vis maybe a small company? And this goes back to the point in terms of the option you have vis-a-vis the consent, right? So I think it's relevant. So these two comments for me to start off. If maybe anybody want to come in on these two aspects. Maybe if I can request Eduardo.
Yeah, I'm happy to make an observation in respect of that. It's really important to understand that in Europe, consent, as Paul has rightly said, consent is one of the lawful grounds for processing, which means that you not always need to obtain consent in order to collect and use personal data. In jurisdictions where there are no other lawful grounds other than a few exemptions, the consent becomes almost ubiquitous, in the sense that you need to have it no matter what. And that has a direct impact on the standard of consent, in the sense that in Europe, if you have other options, the law can afford to have a higher standard of consent, because ultimately consent will be used or will be relied on those situations where there is no other choice but to get consent, because it's not necessary for the contract, or it's not a legal obligation, or it's not someone that is something on that you can rely on legitimate interest and so on. So the standard can be higher, And that standard is uniformly applied. That high standard of consent is uniformly applied, whether you're a small company or a big company, because that is the situation in which you obtain consent. What I've seen in jurisdictions, I think like is going to be the case possibly in India, where is either consent or an exemption, a very limited exemption, then the degree of those standards vary, because there will be situations where it'll be much more important to really ensure that someone has consented than other situations where it would be logical to assume that most people would have consented. And then in practice, that means that there are different standards of consent. But that's in those situations where there are no other options available. That's how I see it.
Yeah, thanks, Eduardo. And I think there's also a provision in our law which deals with voluntary provision of information, and that is something that we'll deal with in the next panel probably. But a great point. And yeah, so one of the other things I think, which again I want to understand from and just purely from an experience point of view in the other markets, is that how have you experienced regulators or even industry dealing with this test that data is relevant for the purpose for which the consent is being sought? So let me just try and give you an example, and I don't really know how it plays out in the Indian context, that collecting data for improving services or retaining it as part of the need to continuously improve services. I mean, is that something, has that ever come under, in your experience, under some sort of a debate, or is it something that that has been fairly well accepted across jurisdiction as to what kind of data is therefore relevant in that context? So maybe Swati, I can ask you to come in and share your thoughts on the test around data being relevant to the purpose and so on and so forth, and any example of guidance that you can share from an Indian context, which would be relevant for us to refer to when we don't have a formal guidance in India.
Sure. I'd just like to make a follow-up point to what Eduardo mentioned and to your earlier question about how regulators are viewing different standards of consent. So, for example, I live in South Korea. For anyone who lives in South Korea and is exposed to how consent is obtained there, they would know that there are multiple checkboxes, and all of them, although those checkboxes are preceded with the requirement, with the word required and optional. So when we are talking about providing consent in that context, there is no freely given consent. When if you do not provide or if you do not click on that text tick box, then you're not allowed to sign up to the service, or you're not allowed to avail that service in the first place. So the regulatory expectation, and in our discussions with the regulator, the way they are viewing freely given and informed is quite different from how Europe is viewing it or how other jurisdictions are viewing it. Freely given, they're more concerned about consent being separated, segregated according to purposes, versus focusing on voluntariness, or how consent is how freely the consent is given. So just wanted to highlight that little point about the jurisdictional difference. To your question right now on how do regulators or what are the standards to ensure that consent is relevant to the purpose, and what happens if the company is wanting to utilize or repurpose that personal information for other purposes such as analytics or product improvement? I think this is a long drawn debate, also something that we've seen debated in multiple jurisdictions. The problem with the Indian DPDP is that it is looking at a consent from a binary lens. So even if you look at the illustrations provided in the Act by way of as explanations, you'll notice that those are about signing up for insurance claims, signing up for bank accounts and things like that. But however, in reality, the world is not the world, like a corporate world or data processing, is not that binary. There are multiple actors involved who are processing unprecedented amounts of data, and whether we like it or not, often that data is, those data sets are utilized, or the companies want to utilize it or repurpose it for secondary purposes. So when regulators are looking at whether those purposes are specific to, the data utilization is specific to the purpose for which the consent was provided, I think it really comes down to questions of the impact assessment that the company has carried out with respect to that processing, to see if the personal information was actually needed for that processing. All personal information or data protection laws are based on the principles of personal purpose limitation and data minimization. So it is really important that those principles are not missed out. The regulators are looking at privacy impact assessment to see that, whether the company actually looked into seeing the relevance of that data when they were considering it for a particular processing, whether it was considered that the purposes or objectives of that processing could have been attained if that data was not collected. So I think from our perspective and in our experience with the regulators, it is typically the privacy impact assessment to show that we considered the purposes and ensure that the personal information that we're collecting is going to be necessary for the purpose that we're collecting it for.
Yeah, Swati, that's an important point, and I want to come to Yun, maybe, if you look at the PD in Vietnam, I mean, are there some, and you heard your co-panelist, just in terms of, experience in Vietnam itself, are there some good practices that you would like to share from which industry can drive some confidence to say that, these are some of the things that they can follow, and looking at it more from a compliance perspective. And then I'll come to the remedy part as a follow-up to that. Anything that you would like to share? Yeah.
Sure, thank you. So to address your question and then also add on to a little to what Eduardo had also mentioned previously. So I think when Eduardo was mentioning jurisdictions where consent serves as the basis for PD processing, personal data processing, but then legitimate interest is not a lawful basis. So Vietnam would be a case, would be a jurisdiction you would think of. And so, right now in Vietnam, what we're seeing is a very consent-centric approach. And how right now, because we're seeing already businesses are seeing how this consent-centric approach is posing potential limitations on their business operations. So these are some comments that are being made to the authorities, being shared among stakeholders. And like in conversations with the government right now, we're sharing jurisdictions where, yes, legitimate interest is not a legal basis, but then there are jurisdictions where the permitting of processing of personal data is based on a business necessity ground. And so these are comments that are shared, and hopefully while we're waiting for supplemental legislation to be provided so that businesses can operate and implement the PDP decree, we're hoping to see all these comments be reflected in these implementing guidelines.
That's quite interesting. I think that's something that probably we should track a little more closely in India. I think that could be very relevant. And I just have a couple of questions quickly, and Bianca, then maybe you have a couple of questions too. So I think we'll probably manage that in this session. Very interesting indeed. So one of the things is that there are, for non-compliance, there are heavy penalties under this law. So and again, anyone can pick to answer this, that when you look at regulators, really enforcing standards around consent, typically, what is the kind of experience in terms of regulatory actions? Is how open they are to giving the leeway to remedy the mechanisms, and so that industry can kind of learn and evolve and kind of settle down, or rather than it is best learning by finding them. So just some on just consent, broad question, but what are the chances of this being a financial penalty kind of a situation? Maybe Paul, Eduardo, yeah.
Yeah, maybe I'll start. I think that really depends also on the regulator. And I think we've seen that when the GDPR went into effect, but you also see it in other jurisdictions when new legislation goes into effect. Initially, the regulators are still fairly willing to provide guidance, to give recommendations, to maybe give some warnings to data fiduciaries, data controllers, that have not understood the law correctly or not implemented the law correctly. But that changes over time. I think in general, you see a few phases in terms of enforcement. First, it's about providing guidance and issuing warnings. Then it is about the initial enforcement action, where everybody expects always that it is the large companies that will be hit first. But the numbers show that actually small and mid-sized companies are affected much more by regulatory action in many jurisdictions. And then we also get the court cases and the class actions, and that's the phase where we are currently arriving at here in the European Union, which is after 5-6 years of having the GDPR into effect. That doesn't mean that if you do not comply, you run no risk in the first couple of years, and therefore you shouldn't comply, because the regulators do have their competences to impose sanctions. But I do think that in general, when a law is new and everybody is still struggling with it, they will be slightly more lenient than if you should already have known.
Okay, that's pretty instructive for maybe in some ways how our data protection board may also look at this in terms of some of the way forward. But any different experience where you've seen early actions by regulators, which we can kind of examine further?
What I would say is that on the whole, if you look at the whole range of regulatory action and enforcement, not much has been done in terms of, for example, fines for not obtaining consent. Very little. But the trajectory is such that there is a risk that at least some practices may be threatened altogether if consent is not obtained. And perhaps the one that is most obvious these days is the context of the use of personal data for targeted advertising in the context of, for example, Facebook. And you may have seen that there has been, again, an evolution where originally Facebook said, well, we need this information in order to provide our service, so this should rely on contractual necessity. Regulators said, well, strictly speaking, you can provide the service without targeted advertising, so contractual necessity should be interpreted more narrowly. Then Facebook said, well, but it is in our legitimate interest to run a service that is for free and everybody is getting the benefit of it. And frankly, the way we fund it is through targeted advertising. And regulators have said, no, we don't think that that's the level of intrusion is such that legitimate interest is not applicable here. So you need to rely on consent, to the point where unless Facebook obtains consent, the authorities are saying you should stop the service altogether. So imagine the implication. That's much bigger, obviously, than a fine if you cannot run your business. And that hasn't happened just yet, but that's the direction of travel. And I think, another point to be made is that, going back to what we were saying earlier about whether consent is the only lawful grounds or there are other exemptions, is that we need to acknowledge that not all personal data users can realistically rely on consent, because first of all, regulators will not be able to enforce the case, every single case. So it is really important that we realize that the interpretation of the law has to be aligned a little bit what we were saying earlier, along the lines of business needs and the reality of the situation. I don't know if this will be a surprise to everyone, but most users of data today do not rely on consent. The way in which our personal information is collected as used in the corporate world, in 99% of the cases, is without our consent. And that doesn't mean it's unlawful, but it is because we don't even know how the data is being used, let alone being able to provide consent. So I think we need to be very careful as to when we require consent, because if we are in a situation where consent is required in 99% of the cases, then regulators are not going to be able to enforce the law, but in only a very, very minute percentage of those situations.
That's very, very instructive in terms of your experience. And in a way, it connects back to what Swati was also saying, that, the impact assessment, once it kicks in, and then regulators probably have better insights, and that also feeds into that cycle of enforcement. And just the very last question from my side, one interesting thing which is there, and we have received a lot of queries from the industry, is that there is a lot of data the industry is already processing. Now the law says that you need to get consent for that, but you do it in a reasonable time. So how do you think about that, and what could be a useful message to the industry in India? And also, are you seeing sectoral regulators put in different standards beyond what is there in let's say, the horizontal law, which could be something that we can look up as industry? So just anyone can come in on this particular point. Yeah.
Yeah, I think, Ashish, with respect to what do you do with the personal information that industry has already collected, and comply, and at the same time comply with the requirement of consent as envisaged under the DPDPA Act, is honestly challenging. And I do not have a good answer to it right now, because we'll really have to wait and wait for the regulatory guidance. Like Eduardo mentioned, that there could be multiple purposes for which data is being the same set of data is being processed. We have a limited legal basis under the Act, which allows for processing outside of consent. So the consent again has to be specific to the purpose. So it is honestly really difficult to understand how this would be operationalized. So is the expectation from the regulators that we need to send out notifications to the individual for each purpose separately for the same set of data that that the industry is already holding about them? That would be honestly an enormous amount of work and quite infeasible. So I do not have a good answer to it. I hope this is clarified in the regulatory guidance. Otherwise, what we'll end up seeing is just a blanket consent being sent out by most companies, which may not really meet the requirements under the law, and maybe the regulators would not would probably consider that as an accepted standard.
Yeah, please go ahead.
No, I just wanted to highlight one other thing, because you talked about the sectoral regulation. So I think a lot of you might know that the Australia Privacy Act is currently under review. And as part of that review, the government actually recognizes the challenges of these consent-centric models. So what they have proposed is that they are contemplating standardizing consent and a notice model. So what they are proposing as part of the review process and the proposed changes in the Act is putting out standardized notices for industry to adopt. The government is also, the regulators also contemplating implementation of a sector probably sector-specific codes, which can be developed and provide standardized layouts, wordings, icons, consent taxonomies. So that is again something that would be really interesting for us to monitor, and something that we can probably adopt and take some cues from.
Yeah, and I think your first answer is very useful, because industry gets that sense that, it's not that at a firm level you are a bit lost on that. I think it just echoes back, and yeah, thanks. And Bianca, sorry, you wanted to come in with probably quick points. Yeah, I think we can take maybe 2-3 minutes. Yeah.
Yeah, absolutely. Then this is perfect. I think just my final question to each of the panelists is, what is really one final word of advice, of good practice for organizations that are here in the room with us today, that are really starting to design their consent mechanisms? What is really the first and most important thing that they need to be thinking about? Yunjung, can I ask you?
Sure. I think that organizations really need to take into consideration a lot of different factors, and also strike a good balance between different factors. You want to protect the individuals. You also want to consider accountability, but you also want to look at, other broader interests, and which I think is the case in Vietnam. And so I think those are some considerations that organizations and all relevant stakeholders need to take into account. But then also, in the case of India, I think this also applies to Vietnam as well. I think we also need to take into consideration the needs of the users, needs of the data subjects, but then also the digital literacy of the users as well.
Thank you so much, Yunjung. Eduardo, can I come to you for your final kind of word of advice on good practice here?
I would say that the most important thing is to create the conditions so that at the very least you can make the argument that people understood how the data was being processed. Because you can get into a very technical legal discussion about whether people click the button or were free to give consent. But at the very least, if you can make the argument of saying, look, our uses of data are very, very clear cut here. We've explained them. They are either very obvious or very clearly explained. That will go a long way, in my view, to be able to at least argue that you are doing it with people's consent.
Thank you so much, Eduardo. And Swati, what is your one final word for attendees here today?
Yeah, I think Yunjung and Eduardo have already included that, but I would say that, consent comes later. Everything else in terms of ensuring that follow the data processing principles, make sure that you are collecting data for specified purposes. You're not utilizing data for purposes that you do not intend to utilize it for. Like future users should be limited, because again, we have very limited legal basis for processing such information. So follow the data processing principles, understand the needs of the users. Also, take risk-based decisions where possible. There is, it seems like a lot, but there's no need to boil the ocean over this. It is important that at the same time, companies are practical and take risk-based decisions.
Thank you so much, Swati. And Paul, last but not least.
In one word, I would say honesty. Be honest about how you process personal data, what personal data you process, and do tell the individuals what you are doing in your notice. Don't leave things out because you think they may not like it, because if that is your assumption, then indeed probably that's true, and then maybe you should not be doing it.
Thank you. And Ashish, I hand back to you.
All right, I think we had a wonderful discussion and some very useful perspective, and thank you all our panel members for joining us here. And believe me, this is just a start of a conversation. We are looking forward to a transition journey, which will take some time, to be sure. So we will hope to get your expertise and guidance on the way forward. And thank you so much for attending. We'll come to a close of this panel. Thank you very much, and we'll be sharing this recording with our audiences. So we'll come back to you feedback on that. Thank you. Thank you very much.
Thank you.